why, we'll present this. Now, when you go to court and you start showing some sort of confusion, you're already biasing the judge. Sometimes people have good cases, but the presentation matters. As you're seated here, you're like, they have argued well. I think they have a point. But sometimes they don't have a point, but they have argued well. They are prepared. I saw some, like I said, I saw some and then also when it came to you're replying to the application, it should be a reply. It should be coordinated to what they are saying at the end of the day. You shouldn't submit from space. We should all have a link, or we should follow, in short. If they are talking about violation, they are talking about archaic customs. You are replying by talking about other countries doing the same. This is Oyanda. You have a constitution. You have the laws that govern you. If they are submitting and they are saying that there was a violation of these laws, and they have specifically told you that there is this right that was violated specifically by imposing these archaic customs, what do you have to say about that? So what am I trying to say? The reply should be specific to what they are putting forward. Because at the end of the day, what you're leaving, the applicant's evidence vis-a-vis your evidence. Now, if your evidence is not coordinated in a way to what they are saying, it is as if you're leaving the application uncontested. So you should stick within, depending on what they have argued. You should know your role as the opposite counsel is to try and convince court that what they are saying is actually not true. But it's not just telling us that it is not true. What backs up your argument? What backs up your argument? I heard you talking about the age, the Constitution putting the age at 16. When I read the facts, the victim 15, wasn't the victim 15? Of? So what was the age of the victim? She was 16. Now, yes, now, if it was 1 day or hours, does it make you that age? It doesn't. So I looked at you justifying a wrong. Is talking about the Constitution of Oyanda. He's talking about, but the person who was the victim in this problem was 15. So you're not qualifying what was done. You're actually on their side telling us that indeed there was violation. I'm going to hit like some other comments come in, so I'm going to be hitting both sides. I didn't hear you talk about the Children's Act. You're dealing with a child who is the age of 18, who is below the age of 16 for that. You're dealing with the minister coming on set and saying anyone who goes into the menstruation period the administration is fit to get married. I think there are issues of children in there. Are they protected by that statement? Don't you think it would have come out a bit? So I think this problem question, to me, I think they were testing you. You don't just look at the facts as they are, but you're supposed to digest and go deep. This is the cover, and see what is inside the problem question. Are you able to identify some issues that have not been put as open, and you identify them? So I think you are also supposed to look at that. You look at the articles, the rights of children. You look at Article 34, I think Clause 4, somewhere there. You look at also, I think, Article 30. You look at also after looking at the Constitution, remember, as you're dealing with other laws, you should also look at the supremacy of the Constitution. Now I'm back to you people. The supremacy of the Constitution. What does it talk about what does it say about customs and other laws that are inconsistent with it? You understand? So you're supposed to look at it in a more broader way, so that the discussion is rich, it is not confined. Usually they used to tell us at LDC that these are the facts, but discover the animal in the facts. So if you're this myopic person, and for you the way the facts are presented to you is the way you take them, sometimes it is a misinterpretation. So sometimes analyze the facts that have been brought to you in order to have a rich discussion with the court. Convince court. Your duty is to convince court that you are right, much as their duty is also to convince court that they are right. So the confidence was okay, although I saw something also about confidence, the starting, but stage fright is a common thing, but you picked up at a later stage, which is also commendable. So apart from those, I think it is job well done, and I think this gives us a platform to improve ourselves where we think we have not done well. Also on the issue of health, I think you were supposed to also to look at the national objective, and also look at, is it Article 18? 8A? 8A1. You also, I think, look at Article 14. 45 is the general application, where the remedy is not, the right is not specifically provided for. That's when you apply Article 45. So I think we're supposed to be broader, look at all the things and make the discussion rich for all of us. Usually don't confine to facts and don't find the animal. Your duty is to find the animal and make the discussion rich and enjoyable for everyone. You should sway the mind of court to your side at any opportunity given. Otherwise, thank you all. I've enjoyed the discussion.
Team E and N, way to move. You need to know your marks from the magistrate, from the judge. Stay there. She's going to come and read for you your individual marks. And just go and read for them.
Miriam? And the other one is? Give me that small book. That one. I'm going to fill from there. Let me first. It is Miriam.
Are their names there in the score sheet?
No, that was even right here.
Where is the file? I think it's
I have it the other side. I'm going to fill in.
It's here.
And then
Let me get all that.
I wanted the names of Jemba is the first person here, I think.
This is team one. And it's okay to change.
This is still E. Team E is that's the applicant. Applicants, Miriam is 70. The show,
What you're going to do after announcing, you have to go and write them immediately.
60. Then Jemba is 50. That is respondent.
Yes. Or
Then,
achieve.
Louis Alex.
Yes.
40.
Okay.
So the overall
So
is,
the total, this is 70, 60.
that is 130.
Divide by 2.
Divide by 2. This is 90.
Divide by 2.
Divide by
This is 45%. For the team. Actually, it's
65.
65.
65.
So Gunda Kubasumera the students for the applicants, CLME, Miriam is Echo this, respondent, Jemba this. Then also go after one DKP or to which one. If you want to take a score sheet,
But they shouldn't do the overall.
no, just tell them their marks as individuals.
They will after you go and put it there.
Yeah, I'm going to do now. Yeah, okay. Hello? Excuse me? These are the marks after going through that rigorous exercise. Miriam, 70%. Echo, 60%. The respondents, Jemba, 50%. Alex, 40% for the respondents. Thank you.
Thank you so much. And I would like to welcome all of you from the first preliminary round and tell you that you are going great into the second preliminary round. So I'm going to the teams that you're passing and please room immediately. The clerk and the judge presiding is going to find you there. So without wasting any time, this is because I Some people came to our desk and they asked why we are doing this, but we want to give you a chance to argue as both applicants, but also as respondents. So if you are an applicant in this session, the next session you're going to be a respondent or a defendant for that matter. Yeah. So, and also your marks for the pleadings and submissions are out. You can check them out there on the flip charts. Later in the day. Team B in Volta. Where's Team G? Yes, you're going to verse Team B in a room called Volta. It's in the corner across the pool. Team M, where's Team M? M, where's Team E? In Mayanja pool. The ground floor. Team L is going to verse Team C in Orange Hall. Are these teams here? I understand that there are two teams that are still in a winding up, but we are going to get them. So Team L, you're versing C in Orange Hall. Orange Hall is just around the corner here. You take the next door and it's around the corner. Team F, is Team F here? Yes, Team F is going to verse Team J in Sezibwa Hall. Sezibwa is around the left corner here. N for no is going to verse Team K. Are these teams here? Team K? N. Is Team K here? Okay. You're going to Kafu Hall. N versus K. Kafu Hall. Kafu is in the next corridor after the next. Team A is versing Team D in this main hall. Is Team A here? Is Team D here? Okay, so I think A is one of the teams that is still winding up a session. So you prepare yourselves on this table. Your session is going to start very shortly. So I request the clerks to unpick helping out and direct them to the relevant halls. Have we all taken note of our halls? Yes. So after the second round, I request that you come back here. It will be lunchtime, but ensure that you have registered your name on one of the attendance lists that are passing around. Please take registration. It is very simple.
We shall have lunch using coupons. So when you're done with your second round, kindly come to the behind table. We shall give you your coupon to go for lunch. Also, in case you've forgotten your team, who you're versing and where you are, the flip chart here speaks to all that. So you can just come and confirm where your team is going and in which room.
Clerks, kindly get in touch with your judicial officers, the judges. lead your team. At least, you know, Volta. You're going to Volta. It's on the upstairs, but across the pool. Yes. So be careful. It's raining, but use the other side. Like
Where's the team going to Mayanja? Where are you guys going?
this. Zeziba is just here. There is a session. There's a session.
Good afternoon. Let's take our seats and my name is Timothy Lum, the judge all around. I'll request you to send me a list of your names so that they can be properly captured on our tallying sheet. Just write down your names and then clerk. So each team will be using 25 minutes. I leave that to you on how you're going to divide the 25 minutes amongst yourselves. My guidance would be that you speak at once, not to introduce, then another person speaks, then the other one speaks. You look at coherence. Okay? So you senior counsel introduce the other colleague, go straight to facts. Get to know your case. Don't quote for me paragraphs. You are now in court. Trial evidence. So you need to know the facts. Certainly, I will be interested in your application of the law to the facts. Okay? I'll be asking a few questions if necessary. If not, I'll leave you to speak. Okay? Because I want to listen in more. Okay, the clerk will read the case file number. Applicants? Respondents? The applicants. So is Singoma and Brian, then Hilda and David. Okay, the clerk will call the file and then we start.
Pen is Mightier Initiative versus the Attorney General of Oyanda and Kwero High School, Civil Suit number 1 of 2022, presided over by His Lordship Timothy.
Do we have a second mic, organizers?
May it please this honorable court, my lord. My name is Singoma S. Samuel, counsel for the applicant, appearing with my co-counsel, Brian Chigundo, in this particular matter. My lords, this is a matter that is brought under Article 52 of the Constitution of Oyanda. But before we proceed into the merits of the case, if it may please this honorable court, I will dwell into the facts of the case. My lords, the facts giving rise to this matter are that in the Republic of Oyanda, it being a poor country, there have been so many things that have not been fulfilled the state and as non-state parties. The facts are that the government of Oyanda failed to protect the rights of the girl child the rights of the girl child when in 2016 a report by the UN Women was put out that 47% and 33% of the girl child in the Republic of Oyanda were dropping out of school due to early pregnancies and cultural practices that were harmful. Child-to-child sex was prevalent in this particular country, and the state has not done any particular party to support the same. The facts further establish that Ariana Kimisha, a student at Guerrero High School, was expelled for being pregnant by the head teacher, Mr. Jean Japierre, little giving consideration that it was the teacher, Mr. Robert Kelly, who was responsible. On her way to get treatment, she passes on due to hemorrhage that had caused sepsis due to the unsafe abortion that had been carried out. It's against that roadmap that the applicants seek declarations that the actions of the state were a violation of various rights guaranteed under the Constitution and other international human rights instruments, as well as the actions of the school not take action against the teacher, was indeed a violation of the school's duty to protect the girl child. Against that roadmap, I proceed on the merits of issue number 1, if it may please this honorable court. On time allocation, I will use 13 minutes to handle issues 1 to 3, and my co-counsel will highlight on the applicant's case on issues 4 and 5. On issues 1, whether the government failed to protect the rights of the girl child against the harmful cultural practices and beliefs, is the applicant's submission that indeed the government violated this particular right. According to the facts, my lords, the minister was quoted saying that when a girl drops her first blood, then she's mature and she can be married off. However, this is an encroachment, an infringement on the right against discrimination and protection of the girl child guaranteed under the Maputo Protocol by Article 5, which is that the states shall take reasonable care and duty to protect the girl child and women from discrimination in whatever way. These harmful practices, according to the facts, include early child marriages. 33% of the girl children in the Republic of Oyanda are being married off, and the state has not taken any part. It has kept silent. It's the duty of the state, as provided for under Article 20 of the Constitution of Oyanda, that it's the duty of the state to preserve these rights, and the national objectives and directive principles are so emphatic on the same under Objectives 15 in the preservation of the right. It's to these harmful effects that the girl child is dropping out of school, they are being married off without reaching the mature age, which is a violation of their right to education, which is a violation of their right to self-determination. My lords, we invite this honorable court to the jurisprudence which is persuasive of Wave versus the Republic of Sierra Leone, in which the ECOWAS court was very emphatic on this particular matter. The duty of the state, of the government of Sierra Leone, to protect the girl child from harmful practices such as rejection and early marriages. And that decision is persuasive in this honorable court in arriving to the particular decision. My lords, Article 14 of the Maputo Protocol gives the state a chance to carry out safe abortions in situations where the mother's life is being threatened. And that same effect echoes the provisions of Article 22, Clause 2 of the Constitution of Oyanda, which allows that abortion can be carried out when it's authorized by law in that particular circumstances. However, which is sad in this particular case, is that Ariana Kemisha goes to the hospital and one nurse, Zifu, declines to grant her safe abortion, yet she's aware that this girl was defiled by the teacher Robert Kelly, that basing on their cultural and religious beliefs, she could not carry out safe abortion for this particular girl. And therefore, it is the right of the state to protect the girl child from such beliefs and practices that endangers the right of this particular girl child. My lords, be that as it may, I proceed to the merits of issue number 2, which are to the effect that whether the government's failure to implement a sexuality education policy is a violation of the rights guaranteed under the Constitution of Uganda and other applicable laws. The applicants vehemently hold that, indeed, government's failure to implement a sexuality health education is a violation of this particular right. In the case of SIHAD versus Attorney General and Family Health Network, 2016, Lady Justice Lydia Mugambe was so emphatic on the purpose of sexuality education. Court established that failure by the government of the Republic of Uganda to come up with a framework in regards to sexuality education was a violation of Article 41 of the Constitution, Section 4.1 of the Education Act 2008, and Article 4.1e of the Children Amendment Act, that indeed requires the government to put in place such a framework that enables the girl child to access this information. My lords, the purpose of sexuality education is to provide the children with knowledge about their emotional, physical, and mental sexuality knowledge about what they're doing. If the government had done so, my lords, then we would not have privileges of child sex, girl child like Ariana Kemisha not reporting, because they would be aware of their particular rights. We borrow jurisprudence and knowledge from Sweden, the mother of sexuality education, that in a report by SIDA, a Swedish firm, established that due to the prevalence of sexuality education, early marriages and child-to-child sex are reduced in Sweden. If the same had been done in this particular country, then the rights of the girl child will not be violated, as the facts indicate.
You have 2 minutes.
Much obliged, my lords. I proceed now to the merits of issue 3, that regards government failure to equip hospitals with consumables, and also having ill-trained its workers as a violation of the right to health. The African Commission guidelines on the concept of progressive resource realization are to the effect that all state parties should put measures and benchmarks that are achievable in order to achieve progressive resource realization. This would mean putting medical consumables in various hospitals. However, it's unfortunate that in this particular case before this honorable court, the nurse referred Ariana Kemisha to another hospital that was 40 kilometers away from this hospital to attain medical consumables, on claims that it does not have equipment and ill-trained. In the case of SIHAD versus the director of Mulago Hospital, court observed that states should not hide under the umbrella of progressive resource realization of limited resources for failure of not providing medical consumables. It should work within all its means to do this. It so appears to us, my lords, that from the time this state of Uganda attained independence, it has not put their measures to make sure that health equipment are in these particular hospitals, and the hospital that's available is distant.
Okay, Council Singoma. In 3 lines, why are you in court?
Much obliged, my lords. We are in court seeking declarations that the failure to implement a sexuality education policy is a violation of the rights of the girl child issued under the Constitution as well as international instruments in which Oyanda is party to. And a declaration that the government should put in place medical consumables in hospitals to serve the girl child and other people that are in need of health resources. It so appears to us that the clinic, Igwe Health Center 3, did not have post-care abortion in that particular hospital, which claimed the right to health.
Have you heard about derogable and non-derogable rights?
Much obliged, my lord.
Have you heard about those rights?
Yes, my lord.
Can you differentiate the two?
Derogable and non-derogable rights. Derogable rights are the rights that at a certain time they can be removed from an individual. These are provided for under Article 44 and Article 45 respectively of the Constitution of Oyanda. The derogable rights may be removed from that particular individual, but the non-derogable rights, such as a right to health, a right to be free from torture, a right to a fair hearing, cannot be removed from an individual in whatever circumstances it may be. But a right like freedom of expression can be removed from an individual in certain circumstances. Article 45 of the Constitution of the Republic of Oyanda is to the effect that other rights that have not been specified or that have not been expressly provided for in the Constitution should be treated as though they are non-derogable. And one of them is the right to health, which is not expressly provided, but corpus juris has provided for it.
Okay, thank you, Council. Let's now hear from Council Chigundu.
Much obliged, my lord.
May it please this honorable court, for purpose of court record, as stated, my name is Brian Chigundu, and I will address...
When you appear in court, senior counsel addresses court and introduces you. So when you speak to stand, you go straight to the point because you're already on record as Counsel Brian Chigundu, so you don't do the introductions again, but you may proceed now. Go straight to the issue and address me on what you were seeking from court.
Much obliged, my lord. Issue 4 states that whether the failure of Quero High School to ensure a protective environment for students to study free from sexual exploitation, violation of human rights granted under the Constitution of Oyanda. My lord, the right to education is a fundamental right, and pursuant to Article 20 of the Constitution of the Republic of Oyanda, it is explicitly clear that these inherent rights are not granted by the state, and it calls upon furthermore in clause 2 that all persons to that effect shall respect, uphold and promote fundamental rights granted under the Constitution of Oyanda. My lord, it is the applicant's submission that contrary to this position, the respondent school, through its failure to ensure a protective environment for her students to study free from sexual exploitation, violated the right to education, which is embedded in Article 30 of the Constitution of Oyanda. My Lord, the question then comes that if this right was then violated, the right to education, then why was Ariana Kemisha in school and as well as other girls? My lords, on that ground, Article 30, to give it its full meaning, it should be read in tandem with Article 44 of the Constitution of Oyanda, which is to the effect that person shall be free whatsoever from cruel, inhuman, and degrading treatment. My Lord, so in other words, the right to education cannot be achieved, cannot be enjoyed if children are not free from exploitation, like in this instance, pursuant to the facts, sexual exploitation that seem to be rampant in Quero High School. My Lord, furthermore, pursuant to paragraph 10 of the instant facts, it is explicitly clear that teachers, while conducting supervision in different classrooms that the students have been allocated, go further, unfortunately, and invite some of the female students to their offices and in the guise of offering them extra lessons. And my Lord, the effect of that is that students then return with signs of withdrawal and not wanting at all to go back for these extra lessons. My Lord, this indicates that Quero High School goes ahead to violate the right to education, read in tandem with Article 44 of the Constitution of Oyanda. My Lord, paragraph 10, of course, the respondent will try to aver that there were no complaints that were ever made about this phenomenon to the administration of Quero High School. My Lord, I will then invite this honorable court to look at paragraph 11 of the instant facts that shows that when Ariana Kemisha, a victim in this circumstance, goes to her inquire, sexually assaulted by a teacher in this school, Robert Kelly, goes to her friends seeking refuge. They rather advise her to keep quiet. My Lord, this indicates that the environment in Quero High School is not protective enough. It has not, the school has not put in place safe spaces where girls can actually confess or put forward their complaints about these unfortunate vices to the administration, hence justifying the applicant's position that indeed Quero High School has failed to ensure a protective environment that will enable her students to study free from sexual exploitation. My Lord, teachers are not hired to exercise their skills of romance with students. Teachers are hired to teach, they are hired to mentor, to nurture. Contrary to this position, a teacher of Quero High School, Mr. Robert Kelly, goes ahead and in a subtle manner persuades a student, a mere 15-year-old, who has not yet even reached the age of consent, to sleep with him, and threatens her that furthermore, if she goes ahead to reveal this affair to anyone, it will be her boyfriend to actually...
5 minutes.
Much obliged, my Lord. My Lord, on this ground, it indicates that indeed Quero High School has failed to ensure a protective environment for her students, especially the girl child, to have the ground to exercise or enjoy her right to education without intervention of this kind of that is put forward by the instant facts. My Lord, with that said, I will proceed to paragraph 15 of the instant fact that states that when this happens, my lord, it's unfortunate that other parents, following the incidents that has happened to Ariana Kemisha, who at the end of the day, following all this in a nutshell, loses her life, go ahead and, in fact, pull out their children from schools as a way of protecting them from these predatory tendencies in schools. And my lord, this also violates the right of education, as parents or the is losing faith in the schools that are there to rather educate the children of the Republic of Oyanda. And my lord, I will invite this honorable court to strongly consider the fact that education is very central to a human being's life, especially the girl child, and find in favor of the applicant. My lord, furthermore, I will submit on merit 5, which states that whether the failure of Kwero High School to investigate and prosecute Robert Kelly was a violation of Ariana's rights granted under the Constitution of Oyanda. My lord, the question still remains. If no complaints have been made about these allegations to the administration, then what exactly is the problem? My lord, the protocol to the African Charter on Human and People's Rights, on the rights of women in Africa.
You have 2 minutes.
Much obliged, my lord. Obligates state parties to take appropriate measures to eliminate all forms of discrimination against women and ensure equal access in the sphere of education and training, protect women from all forms of abuse, including sexual harassment, both in education and the workplace. My lord, contrary to this position, the respondent school fails to prosecute Robert Kelly, even when the nurse, Miss Christine Gwango, is aware that Robert Kelly is actually a face to focus on.
Take the allegations further to the administration, and it still brings us to the question that I have initially brought forward, that then if these complaints are not being put forward to the administration, that then it should take action. What exactly is the underlying problem? The underlying problem is that this school is not fulfilling its mandate by according enough protection to her students, and that's why it even fails to prosecute Robert Kelly.
The teacher who impregnated Ariana Kemisha, a student that at the end of the day loses her life to this whole circus. Lord, in conclusion, the applicant prays that damages be awarded to the applicant as against the second respondent, and my lord, the applicant of this suit. If I'm of no further, I beg to submit.
Let's start it from there. You want
Much obliged,
damages,
my lord.
and costs. What are damages?
Damages, I'll borrow the jurisprudence of George Chigundu versus Attorney General, where damages were talked to include general damages, exempt damages, etc. My lord, damages it's a pecuniary compensation that is awarded to a plaintiff for the loss they have suffered as a result of acts or omissions of the respondent or whatsoever that may be.
Are you familiar with Article 20 of the Constitution of Oyanda?
Yes, my lord, I am familiar.
Okay, can you read it for us?
Of the Constitution of Oyanda provides for fundamental and other human rights and freedoms. Clause 1 of the same provides that fundamental rights and freedoms for the individual are inherent and not granted by the state. Clause 2 provides that the rights and freedoms of the individual and groups enshrined in this chapter shall be respected, upheld and promoted by all organs and agencies of government and by all persons.
What's your interpretation of that article?
My lord, I interpret this article in a sense that fundamental rights that are enshrined in chapter 4 of the Constitution of Oyanda are inherent and should be upheld. In other words, should be considered, given priority that they deserve by all persons and agencies of government at all cost.
Okay, thank you so much, Council Brian Chigundu. We shall now hear respondents.
Much obliged, my lord.
Please proceed.
I beg to submit.
Much obliged, my lord. May it please this honorable court, I'm Ora Hilda, appearing on behalf of the respondents with my colleague, Simbwa David, and we've been given 20 minutes. We were given 25 minutes by the court, and I'll use 12 minutes of this honorable court. I'll begin with the brief facts. The application by the applicants asserting that the government of Oyanda and Kwero High School acts and omissions led to violation of human rights, and that the state maintains harmful cultural and religious beliefs and is reluctant in passing a school health and sexuality education policy, that the government workers are neither trained nor the essential equipments, and the school also failed to provide a protective environment for the students to study free from sexual exploitation, and the alleged perpetrators of sexual violence are not investigated and prosecuted by the school. My lord, if it may please this honorable court, may I proceed with the issues?
Please, the floor is yours. Just make sure that you go to the issues, submit on the issues, because you have only 12 minutes.
Much obliged, my lord. Issue 1, whether the failure of the government to ensure that girls were protected from harmful and predatory culture and religious practices and beliefs under K clause is a violation of Articles 21, 24, 34, 3 of the Constitution of Oyanda and applicable laws. And issue 2, whether the failure of the government to pass and implement a school health and sexuality education policy is a violation of the right to health, education and access to information guaranteed under Objective 14 of the National Objectives and Directive Principles of the State Policy under the Constitution of the Republic of Oyanda. Issue 3, whether the failure of the government to provide essential training and equipment to the government medical workers to enable them to handle issues arising out of teenage pregnancies is a violation of girls' rights in Articles 28, 22, 1 and 2, 33, Clause 2, and others guaranteed under the Constitution of Oyanda and the applicable law. Issue 4, whether the Kwero High School to ensure a protective environment for students to study free from sexual exploitation was a violation of human rights guaranteed under Articles 21, 24, 34, 2 of the Constitution of Oyanda. Issue 5, whether the failure of Kwero High School to investigate and prosecute Robert Kelly was a violation of Ariana's rights guaranteed under Articles 24, 21, 34, 2 of the Constitution of Oyanda. Issue 6, the remedies that the parties are entitled to. My lord, I'll proceed on resolving the first 3 issues, and my colleague will resolve the rest issues. The applicants contend that there was no proof of cultural contend that the government failed to ensure protection of girls from predatory cultural and religious practices and beliefs, which in particular is the rampant practice of child marriage. There is no proof of the cultural beliefs that are complained of. My Lord, under Objective 24 of the National Objectives and Directive Principles of the State Policy of Oyanda, provides that culture and customary values which are consistent with the fundamental rights and freedoms, human dignity, democracy within the Constitution may be incorporated in aspects of the Ugandan life, of the Oyandan life, and the Constitution, and the state shall promote and preserve those cultural values. Furthermore, under Article 1 of the Convention of the Rights of Children, defines a child to mean every human under the age of 18 years. And furthermore, under Article 7 of the Constitution of Oyanda, provides that the maturity age of a child is 16 years. Oyanda State entered a reservation of Article 6B and 14.2C of the protocol. People's rights on the rights of women in Africa, that is the Maputo Protocol, on the age of consent as provided for under the Article 7 of the Constitution. It is now submission that the said cultural practice is non-existent, it does not exist, and the state, it does not exist in the state, and the applicants' arguments are based on mere reports by the individuals that have interest in this matter. Furthermore, the applicants contend on the quotation of the minister, which is public opinion, which was on the radio, Giza Radio, and also on national television, under Article 29 of the Constitution of Oyanda, freedom of expression, and a person is entitled to his or her own opinion. And furthermore, the words that were said by the minister were binding to only the minister and not to the state of Oyanda. Furthermore, my Lord, I would like to proceed on issue 2 and 3. I'll take them concurrently. The applicants contend that the government derogated from its state obligations by omitting to pass a school health and sexuality education policy which violated the crucial human rights for the girls. And such rights include right to non-discrimination, right to life, right to health, right to human dignity and protection, right to welfare, among the others. My Lord, the respondents recognize that provides for the rights stipulated under Article 28, 22, Clause 1 and 2, 33, Clause 2 and others. The respondents are also, we are also aware that the state has a constitutional duty under Objective 24 of the objective principles of the state policy in the Constitution to endeavor to fulfill the fundamental human rights of Oyanda to social and economic development, and in particular ensure that the developmental efforts are directed at ensuring maximum social and cultural well-being. Furthermore, the applicants contended that there were no equipments that provided for post-abortion care, but we are well aware that in the state of Oyanda, abortion is illegal. And Article 12, Clause 1, and Article 16 of the African Charter on Human and People's Rights also places an obligation on the state parties to take necessary measures to protect the health of their people and to ensure that they receive basic medical attention when they are sick. My Lord, My Lord, all international and regional treaties provide for the progressive realization of the full enjoyment of the right to health and to the highest attainable standard. In Sehad and others versus Attorney General of Uganda, the right to health was understood as an enjoyment of variety facilities. However, it should be appreciated that the highest attainable standards are based on the recognition of that right to health and education and also economic rights. If it pleases this honorable court.
Counsel Hilda, what is it that you are defending in court? What is your defense?
My defense is that one is individual responsibility of the minister. Then the other is there's no proof of cultural beliefs they complained of.
Did you listen to their submissions?
Yes.
What is your response?
Well, my response is that when they talked about what the minister had quoted on the national television and also on Giza Radio, this was his own public opinion, and the state was not entitled to it.
Okay, thank you, Hilda. We shall now hear from Counsel Simbwa.
Much
David.
obliged, my lord.
Much obliged, my lord. My lord, I pray to be excused from using the microphone. My lord, I'll use the remaining 30 minutes to resolve and reply on issue 4 and issue 5 and also make our prayers. And if it may please this honorable court, I pray to proceed. My lord, in the applicant's submission in relation to issue 4, they are faulting Kwelo High School for having failed to provide a preventive environment in order to enable students to study free from sexual exploitation. However, under 101 of the Evidence Act, as it was interpreted in the case of Jonas Toyambe and another versus the Anthony and the Registrar of Cooperative, the High Court of Uganda determined that any person who desires court to make a judgment dependent on particular facts, and the person should prove their existence.
Continue, Counsel.
My lord,
To use the mic.
much obliged. My lord, Father, the prosecution, I pray to amend, the applicant to prove what amounts to a protective environment. However, it will not be an issue to us, and we shall prove so. Referring to Chapter 2 of the Indian Recommendation towards the National Child Protection Policy, a protective environment was defined to be an environment in which basic health care, need, and safety are ensured for a person who cannot provide such services. Under these recommendations, particular components were also recognized for that they should be in existence for a protective environment to also be in existence. Among them, it is that there should be safety and freedom from abuse, neglect, and exploitation of any form of violence. My lord, Kwelo High School 20, clause 2, such rights. It adhered to such rights by carrying out particular measurements, whereby it separated students, male from females, and they were made to sit in different classes, and this was aimed at preventing them from being induced to engage in sexual activities. My lord, Father,
under Article 27 of the African Charter on the Rights of a Child, it is recommended that such measurements should be made in order to prevent sexual exploitation. And it's our defense
that Polo High School did not default its duty, but however, it took necessary measurements. Proceeding to issue 5, the applicants. Proceeding to issue 5, the applicants told Polo High School to investigate and prosecute Robert Kelly, and they allege that this was a discrimination of various rights guaranteed under the Constitution of Guyana. My Lord, it is tried that in criminal prosecution, it is not the duty of any person to prosecute. However, it is the duty of the state. I would like to address this Honorable Court to Article 120 that establishes the Office of the Director of Public Prosecution, and it also establishes the duties of the Director of Public Prosecution. Among those duties, it is to order police to investigate on such matters. Further, and also to report to court any person who is under any question. My Lord, further, under Section 4, subsection 3 of the Police Act, it is to the effect that no person shall arrest, detain, or institute criminal proceedings except as provided under a written law or the Constitution, since it is not the duty of Polo High School to prosecute to carry out investigations and prosecute on criminal matters. It omitted nothing, and there was no right that was violated. However, it can come to a question to this Honorable Court whether the act was a criminal offense within the meaning of defilement under Section 129 of the Penal Law of the Republic of Uganda. Forcing a child who is under the age of consent into a sexual activity, it amounts to defilement. And it does not count whether he or she, whether she consented or not. And this is the act that the respondents depend their case on. And it is our submission that it is a criminal offense. My Lord, if it may please this Honorable Court, I beg to make our prayers.
Proceed.
The applicants have proceeded under Article 50, which mandates them to file any application where there is a violation of a human right. However, they have failed to prove their case. And therefore, as the respondent, we pray that this case is dismissed with costs, and it is declared that the applicants are not entitled to any declaration. And so, sir, I so pray.
Simbwa David. Principle of progressive realization of a right to health. Can you submit and demonstrate how the state of Ayanda has demonstrated the right to progressive realization of a right to health?
My Lord, under the concept of progressive realization, a state is mandated to enforce human
rights to an extent that is within their resources. It should be put into consideration that the Republic of Ayanda was a victim of the pandemic, COVID-19, and does not have enough resources. However, it has ensured to provide various medical services. The applicants contended that the Health Center 3 had no required equipment to handle issues arising out of abortion. However, it is also their submission that Ariana was referred to a bigger hospital, which they believed that this hospital has those equipment, and therefore the government cannot be faulted for this health center not having those equipment, but it was providing what it is within its means, and such equipments were provided in a bigger hospital. And if she had reached there, she would have got that particular treatment.
Okay, thank you so much, Council Simbwa David.
For 2 minutes to tally the results. Okay, we're back in session. I'll congratulate all of you participated in this activity. The law profession, noble profession, it is very prestigious. By default, that we are over average, because that's the legal profession. When you participate in such activities, it is a plus, because I know how time consuming it is. I know how tiring it is, and it's also a sign of confidence. So congratulate yourselves. Do not mind about the results. Okay? Don't mind about the results. It's a learning experience. Okay? It's not a war. Okay? It's actually more, when you participate in such things, it's more about networking, meeting new friends, and of course learning. Okay? Of course learning. So going forward, in the event that you make it to the other rounds, one, I've noticed that both of you do not know your case or your respective cases. When you're a judicial officer, it is a battle of the brains. You don't want to appear before a judicial officer and you are reading notes. You know, you look like you're not prepared. When you appear before a judicial officer, it is business. That's why you put on that robe, because we expect you that you only put on that robe when you're in court. It's a sign of seriousness. When you leave court, you remove it. We don't want to find you in Owino putting on our robe. It's a battle for brains, so you prepare. That is what it means. You prepare. Trial is about evidence. Council Hilda, you quoted so many laws. The judge knows the laws. He has been in school. He has decided cases. He knows the laws. He wants to hear more about why are you in court? Okay? Why in court? And those are facts. Those are facts. So going forward, one, I want you to get to know your case well. Okay? Get to know your case well. Two, make a list of points that you want to present to the court. It's not everything. You could actually even reach here and say, my lord, whereas the submissions list 4 issues, we concede to issue 1 and 2. Therefore, the issues that are triable are 3 and 4. So that you move on to what is in dispute. Okay? Then lastly, it's also important that while presenting your case, you should argue upon the facts rather than the law. Yes, we want to hear, is the student familiar with the national laws? Are they familiar with the international instruments? That's okay, because it's part of the assessment, but the facts, which is your case. So both of you, if you make it to the next round, I want you to read the brief again and have it on the fingertips. Okay? You're dealing with the right to health. You're dealing with human rights. You should know that chapter on in the. You should know that, because that is what is in issue. Okay? That's what is in issue. That having been said, I once again congratulate you, and please do not be disappointed by the results. Of course, you know, in every competition there's a winner and there's someone who has tried. Okay? Certainly we recognize that you are far much better than someone who joined law school and will live out the way they came in. When I was a student, I was guild president, guild tribunal, students tribunal. Little end up being a judicial officer, but I was one of the members who used to resolve students' disputes. So ensure that there is a mark that you leave behind when you are at the university. So for the applicants, this is how you scored. Council Singoma Samueli, 74. Council Bran Chigundu, 73. For the respondents, Council Hilda, 59. Council Simbwa David, 61. The 73.5. Average for the respondents, 60. But like I said, sometimes depends on the, like there was a lot more, you know, I feel like there was a lot more. So even Council Singom and Bran, as you celebrate, if you're going to make it to the next round and you find me on appeal now, I might get a promotion from now, and the next time you meet, you will find me at the Court of Appeal. If you make those submissions, rest assured, we shall not very much luck for the next round.